North Carolina General Court of Justice Superior Court Division. Stephen McRae vs. Kyle Russell Curtis. Guilford County 19 CVS 8163. Transcript, Volume 1 of 1 pages 1 to 35 Wednesday, September 16, 2020. Honorable James L. Gale, Judge presiding. Motion to set aside entry of default and partial default judgment. Appearances, for the plaintiff, C. Scott Myers, Attorney at Law. Connors Morgan, PLLC 1175 Revolution Mill Drive, Suite 8 Greensboro, North Carolina, 27405. For the defendant, Scotty Forbes Lee, Attorney at Law. Ellis and Amb. Winters, LLP, P.O. Box 2752 Greensboro, North Carolina, 27402. Shari Rogers, RMR, CRR, CRC Official Court Reporter, Division V. Rover Post Office Box 2208 Weaverville, North Carolina, 28787. Shari G. Rogers at courts.org. Proceedings commencing at 10 a.m.
Good morning, everyone.
Good morning, Judge.
Good morning, Your Honor.
Let me start out by first thanking Ms. Rogers for being here with us this morning. You oftentimes don't get to speak, but you are one of the most valuable people here. We very much appreciate you being here. Where do you join us this morning?
I'm out in Buncombe County.
In Buncombe County.
Up in the mountains.
Be a nice day to be in the mountains. Thank you for being with us.
I'm getting a bit of an echo.
I'm going to ask Scotty and Scott to mute themselves except when they are speaking to the court, and as long as you've got two people on, sometimes we get the echo. I noticed when Scotty was testing before, I had a little bit of echo as well. Did that cure it?
It did.
Alright. And so I think there are several participants on the phone, and Ms. Collette has had a set of instructions on the screen, but I'll join and amplify those. That is that I ask everyone to please be muted whether by video or phone except when you are addressing the court. For those people who are not participating as in the hearing, I would ask that you also not have your video live, but you are welcome to participate. This is an open court proceeding, but I ask that you mute. Occasionally if I have to interrupt, I've had occasions where people refuse to honor that instruction. We have the ability to tell who is muted and who's not, and only once have I actually had to disconnect someone from the hearing, because they simply would not abide by the rules of the court. But it's simply to prevent them from being an echo so we all can hear. The other thing is that the court reporter, Ms. Rogers, is here. She is the only person that's entitled to have an official transcript of the hearing, and I know that sometimes those things are transmitted otherwise, but only the court reporter has the authority to issue a formal transcript. That being said, let's go ahead and make appearances, and for the plaintiff, Mr. Myers.
Yes, Your Honor. Scott Myers for the plaintiff Stephen McRae.
Okay, and is Mr. McRae on the phone before the court this morning?
I do not believe Mr. McRae is on, Your Honor.
Okay. Ms. Lee, for the defendant.
Scotty Lee for the defendant Kyle Curtis.
And is Mr. Curtis on the phone this morning?
He is not to my knowledge.
Alright. Thank you very much. Alright, the court has read the materials in the file, and the only matter before the court this morning is the issue to set aside the default, which raises the issue as to whether or not the court has obtained personal jurisdiction over the defendant, Mr. Curtis, by reason of the initial issuance of the summons in the complaint. I have read the case law, I've read the affidavits. I have questions, but I will entertain first an argument. We'll go back to Ms. Lee. It's your motion to set aside, so I'll hear from you first.
Thank you, Your Honor, and I know you've read the briefs, and I don't want to rehash that too much. I just want to talk for a few seconds about the standard of review that governs the motion to set aside, which I think is really important here, and the provisions for setting aside a motion for default under North Carolina law must be liberally construed. The purpose of that standard is to give the parties an opportunity to have the case disposed of and decided on the merits. The law disfavors default judgment for that very reason.
I'm certainly familiar with that. I would say to you that there's a combination of what I think is before the court at this point in time. There's been the service by certified mail, which raises a presumption of service. There were several months had gone by, And depending on what affidavit you believe or don't believe, and what you take or don't take as far as veracity of YouTube findings, there was a period of months on whether or not that there had been service, that Mr. Curtis knew of the lawsuit and elected not to respond. That doesn't mean that service is valid. I also understand the law to say. I do think it speaks to the issue of whether or not you get the liberality of setting aside a default if, in fact, you are willingly ignorant of, you're aware of the lawsuit but purposely elect not to appear before the court. It doesn't. I understand your case law to say that notice of a lawsuit does not make effective service effective, but I do think it goes to the liberality of the standard of review that you're asking the court to follow. So I will say to you here, if I find that there was, in fact, valid service, and if I were to give any veracity to Mr. Curtis's comments, if they are, in fact, proven that he was aware of the lawsuit and chose to ignore them, and that he purposely and willingly failed to abide by the judgment of the court and waited some time to set it aside, I've made it apparent early the harshness of which I would view that. So I appreciate your citings to the court, the standard of review of which it's aware, but I would take issue with you saying that he necessarily is entitled to the same liberality that others would be under these circumstances. So I'm most concerned about whether or not there has been valid service or not. The critical issue in that regard is I believe that moving forward raises a presumption of service and has to be disproven, so I'm most interested in your argument as to say why that presumption is not there.
Thank you, Your Honor. Understood, and we would argue that the presumption of service has been rebutted for 3 reasons. First of all, Mr. Curtis has submitted ample evidence. I realize there are contradictory affidavits, but ample evidence showing that he did, in fact, live at the Charlotte address during the period that plaintiff attempted service on him. First, Mr. Curtis has submitted multiple notarized affidavits from himself and one from his mother to that effect. He has submitted other paperwork, including bank statements, a lease agreement, his 1099, his W-9 form, and an Amazon receipt, which I realize is not binding, but just to show, just to offer a variety of documents showing that Mr. Curtis did, in fact, live there. We believe that, on this first point showing that Mr. Curtis was living in Charlotte as of July and August of 2019, these items together are sufficient to rebut the presumption that Mr. Curtis lived in Pleasant Garden on the date of the attempted service.
Let me ask, as to, we talk about standard review. Let me ask to see whether we are in agreement as to what the case law is that the court is to follow. You cite the Osman case. Madam Court Reporter, that's OSMRN. The Osman case to stand for the proposition that absent valid service, actual notice is not sufficient for personal jurisdiction. It also cites the Granville case, and the Granville case indicates that there is a presumption, and that once there's a presumption, it is for the court's determination as to credibility and to make a finding of fact as to under the evidence. Do you agree that I have before me and it is for me to determine whether or not I believe Mr. Curtis's testimony that he did not receive the papers that were served upon his mother?
I believe so, Your Honor. It is the court's job to weigh the credibility of the evidence, and I would agree with that, yes.
And then in that regard, you talked about Mr. Curtis has filed multiple affidavits, and he has. Other than the affidavit that he filed, I believe, on the 24th of August, is there any other affidavit that he filed that says that he did not receive the papers that were served upon his mother?
No, Your Honor. The reply affidavit, which I believe is the one that you're referring.
In the several affidavits he filed before August.
Right.
He did not say that he did not receive the papers from his mother. He simply said,
correct.
I was not served in Charlotte.
Correct.
Is there any affidavit in the file from his mother that she did not send the papers that were served upon her to Mr. Curtis?
She did not say that in her affidavit, Your Honor.
And is there any affidavit, other than the affidavit that Mr. Curtis filed on the 24th of August, that says that his mother was not an authorized agent to receive mail on his behalf?
No, Your Honor.
Okay.
So as I was saying, we believe that the evidence shows that Mr. Curtis was living in Charlotte as of the date of the attempted service. We also have shown, going to the rebuttal.
Would you agree that even if he was living in Charlotte, If the papers were served upon his mother, and she then promptly delivered those to Mr. Curtis so that he received the papers, with the presumption that Rule 4 allows, would that have been adequate service to convey personal jurisdiction?
I think that if Mr. Curtis had not rebutted the presumption that his mother is his agent, and I think that he also under the law would have had to, in fact, receive the papers from her. A phone call, for example, wouldn't suffice.
But I ask you the question, is it the mother received them, signed the return receipt, and then delivered the papers to Mr. Curtis and he received them? Would that have been adequate to convey personal service?
I believe so, yes.
And also, just so that I know where the fact record is that we're all arguing, when Mr. McRae first sought to compose a judgment by default and there was the issue, the court at that point in time had never received an affidavit from Mr. Curtis that he did not live in Pleasant Garden, and so the court made a point of saying that the complaint had not been verified. That the court itself would serve its order on Mr. Curtis at the address that was available to the court, or the court then mailed its order to Mr. Curtis. Mr. Curtis has never said that he did not receive the court's order. Did he receive it?
Your Honor, so he did not, and that is a result of his first affidavit that he filed in which there was a typo in the address, and we addressed this in our brief in support.
Now, Ms. Lee, when the court served that, it served in Pleasant Garden, because the court had not yet been made aware. It did not have any affidavit of Mr. Curtis. He did not make an appearance at all, and I said I did not want to enter a default judgment without making an effort to tell him that default had been entered, and that I was considering default judgment. I mailed my order to Mr. Curtis at the only address I had available to me, which was Pleasant Garden at that point in time. Mr. Curtis had not filed anything, and your various affidavits never say that he did not receive the court's order. Did he receive it?
I didn't tell you that he received notice of it at some point. I cannot, as I sit here today, say whether he received that in the mail, a physical copy. I do not know that, Your Honor.
If I find that there was, in fact, valid service, you understand the significance with which I would put if Mr. Curtis chooses repeatedly to ignore the court?
Absolutely, and Mr. Curtis is aware of that too.
All right. Go ahead. I've interrupted you several times, but we now know what the record is.
Yes.
What am I to, in making my credibility determining, what am I to make of Mr. Curtis's statements and YouTube proceedings, including the precise statement, did you receive the papers? Yes, I did. What am I want to make of that?
Your Honor, well, first of all, we would argue that that evidence is not properly before the court, but we know that at some point he received notice of it. He did not. He has testified in a sworn affidavit that he did not receive the actual complaint until several months later.
That's what he said in one of those affidavits.
Correct.
If I were to find that he, in fact, gave a statement, admittedly not under oath, but gave a statement on YouTube, observed by someone testifying and able to testify and authenticate that it was he that I was watching, and he made the statement and was asked, did you receive the papers? And his answer was, yes, I did. What significance would that, should the court place on that statement?
I think that it would go to the credibility of the weight, but it would not, in my mind, it would not, override the sworn testimony of Mr. Curtis.
Do you believe the court has sufficient jurisdiction now to order that Mr. Curtis be placed under oath and be deposed?
I do.
All right.
I do, if it were in connection with this, the current motion that's before the court now.
Yes.
Yes.
I've got to determine whether I believe his testimony that he did not receive the papers was credible or not.
Understood. So, Your Honor, we would argue that the Osman case, which you're familiar with, is instructive here. We have basically the same fact scenario as we had in Osman, a couple of variations, with, one caveat, and that's that in Osman, the plaintiff, or the defendant was actually served at a correct address, his principal place of business. Here, we argue that Mr. Curtis was not served at a correct address, so that's the distinction there.
But even in Osman, there was an initial presumption that service was valid.
Right.
What the court found was the presumption had been overcome.
Correct. And that's what we ask you to find here, Judge. I mean, that's all we have here on the motion to set aside. I think, we'll rest on our brief.
I'll certainly let you respond to Mr. Mayers as well. Mr. Mayers, the floor is yours now.
Thank you, Your Honor. I would just mention briefly about, since Your Honor asked about the recordings and the authentication of those recordings, I think the case, one of the most recent cases from the Court of Appeals talking about video and audio recordings is State v. McGee, 766 SC 2nd 698, and the court says ruling, deciding on North Carolina Rule 901, says that all that is required to authenticate an audio tape recording is the witness's testimony to the identity of the declarant based on personal knowledge. I think we'd got, declarations in front of the court, both of who made them and who made the recordings and the video, and testimony offered, affidavits from Mr. McRae that it was actually the defendant on the recordings and on those videos. So I think those are properly authenticated and are for the court to review, making its credibility determination. Your Honor, I would just like to set the scene for just a minute as to how this case came and how the service came, and all this is in front of the court in some of the previous motions. This dispute had been brewing for quite a while. Mr. McRae served, hired counsel in North Carolina. There were multiple.
I've got my arms around. I recognize there are other people that you may want to educate, but the court doesn't need the education. The court is certainly familiar with multiple briefs and affidavits that have been filed.
Thank you, Your Honor. Then I won't belabor the point, and so just getting to the presumption, I think everybody agrees that the presumption has arisen in this case by order of the rule, that it's not been disputed. The certificate of service, it was served, it was signed for, the return receipt came back, and it was filed with an affidavit to the court. So at that point, by operation of the statute, the presumption arises and what it becomes is incumbent on defendant.
We all agree that the presumption is there, and I've got to judge the credibility of whether it's overcome or not. What say you, Mr. Mayers, about what is the significance of Mr. Potts' affidavit, and what am I to do with the fact that Mr. Curtis's most recent affidavit was that Mr. Potts has filed an affidavit under oath at this point? What am I to do with that?
Well, Your Honor, I think you weigh the credibility and the totality of the circumstances in this case. Mr. Potts, in order to look at the credibility between Mr. Potts and Mr. Curtis, you basically have to believe that an angry ex-boyfriend decided to insert himself into this case at the last minute and perjure himself.
But Mr. Curtis did put before the court Zelle indications that he had monies withdrawn from his account and were paid to Mr. Potts, with the suggestion obviously that those were end payments, which documents that they were.
Right.
And a statement that Mr. Potts just simply didn't remember signing the affidavit and rental agreement because he was drunk. Now, obviously, Mr. Curtis has indicated that he was waiting on certain matters that would come from text messages and from his discovery and how Mr. Potts had responded, but, I've got two diametrically opposing affidavits put before me under oath. I'm reminded when I was clerking a long time many years ago. It's been a long time ago.
Not that many years ago, Your Honor.
Pushing 50, but when it was in federal court and the situation of two diametrically opposite affidavits, and when called upon to judge the credibility of diametrically opposing affidavits, the federal judge for whom I was clerking says, I simply don't know that I'm the best person to make that affidavit. I believe I'll let the U.S. attorney make that determination. What am I to do with two affidavits filed under oath, filed with the court through counsel that are diametrically opposite? They can't both be right.
Agreed, Your Honor. So I think you'd have to look. I think it's the court's job to look at those affidavits and look at the witnesses in total. So you only have one affidavit from Mr. Potts. You have multiple things from the defendant that you would have to believe in order for his affidavits to be correct. For example, Your Honor, you're going to have to believe that, like I said, a jilted ex-boyfriend would insert himself into this case.
Let me, and I'm interrupting a lot.
Sure.
And I will let you both respond, as I certainly can understand multiple affidavits versus others. I would also tell you that Mr. Curtis has been forthright to say that he can't explain why the barcode on discovery would show a zip code for Pleasant Garden. I will go and confess to you that the court used the same technology to look and the barcode showed us that they were, but he indicated he downloaded them as basically mailed. If I were to find that there is personal jurisdiction, then that is a matter that can be immediately appealed and on appeal. And so my question to you is, do you think the court should do anything else to develop the record as to whether or not? Because again, if I find that Mr. Curtis's testimony should be believed, Ms. Lee has pointed out that if he rebuts the presumption of service, then there is no personal jurisdiction. By the same token, if I find that he's not met the burden of presumption and it is personal jurisdiction and a suggestion will develop, well, that is a credibility determination for the court to make. But if I were to find that there was and has been personal jurisdiction in light of the subsequent proceeding on the default judgment, etc., that the court has got separate issues that it's got to deal with on a show cause issue, etc. So before we go down that road, I'm interested in both of you saying whether or not I should take the record that we've got by way of affidavit and make the findings and see where it goes, and whether or not each of you want or should be asked to take the opportunity to subject the two witnesses to deposition testimony with full challenges to affidavits so the record is complete as to what I'm supposed to make in a determination as to whether it is or not. Ms. Lee is exactly correct. If I find that he's adequately said his mother did not have agency, she, herself, has not said that, and that the papers were never delivered, she, herself, has not said that, then there is a strong argument under the law that actual notice is irrelevant. So I need to know what both of you guys think I ought to do, and do you think I've got an adequate enough record to go ahead and make, recognizing the very significance, the importance of what the court finds and the fact that it triggers an immediate review. What should I do?
Yes, Your Honor. Well, from our standpoint, even before Mr. Potts' affidavit was filed, the court had more than enough on its, in the record to determine that the presumption arose and has not been rebutted simply by even by the statement that, the evidence shows that, the only evidence on the record that Mr. Curtis didn't receive it is his own statement that his mother did not give it to him, which was not filed until more than a year after the service.
Wait.
Or about a year after the service.
Wait a minute, what did you just say? Did you say the mother says she did not give it to him?
No. The only evidence that the mother did not give it to him is Mr. Curtis's own statement that he did not receive it from her. That's the only evidence. The affidavits from Mrs. Curtis just say that, that she signed for it and he didn't live there. So that was the witness's own statement or the defendant's own statement is the only evidence there to say that he didn't receive it from his mother. And the evidence of actual notice is replete. We've got the Discord recordings, the YouTube video where he discusses in detail how he didn't receive it, or how he did receive it and didn't respond, or when he says he's ready to rumble. Before the response deadline expired, he said we're going to respond and we're ready to rumble. That's obviously, at no point did he say, hey, I never got it so I don't have to respond, or I never received it. I don't know what you're talking about. So there's plenty of evidence, Your Honor, for the court to go on to decide that the presumption arose and he had actual notice, and that's all we need under Granville, and that's it. The Potts affidavit and the Joyce affidavits or declarations, really just end up piling on additional evidence showing that, why Mr. Curtis's last affidavit or last two affidavits really shouldn't be believed. That, it's been stacking, misrepresentation on top of misrepresentation, and we thought it was important to bring those to the court, because as Your Honor has rightfully pointed out, there's compelling evidence of a potential fraud on the court if there's not some kind of reasonable explanation, and that's not been supplied to us yet.
Let me ask this. Once you have the presumption in place and the role of the court is to judge credibility, am I bound by the rules of evidence?
Your Honor, my understanding of the rule of evidence always has been is that they're much more applicable in a jury context than they're for the court. The court is uniquely able to judge the veracity and admissibility of evidence and whether it should be considered and give it the correct weight.
Am I able to consider solely for credibility purposes out of court statements that Mr. Curtis made, and Mr. Curtis has never said in his affidavits, I did not make the statements that are recorded in the 6th of October, 2019, YouTube transcript, am I entitled to consider it?
Absolutely, Your Honor. I think you've got the evidence in front of you where it was recorded. That was Mr. Curtis. And as you pointed out, Mr. Curtis has had multiple opportunities to come forth and say that's not my video, or this is the whole video, or that was altered, and he's never taken that opportunity to do that. It's clear that, so I think the court definitely has the discretion to find that those were credible.
So you're satisfied that I should stand on the record as it exists? You're not wanting to, accepting the opportunity of an offer to depose Mr. Curtis?
That's correct, Your Honor. I think the record is more than full that that there's plenty of evidence in there. Now, if the court is inclined to give those, then we would ask for additional time to take some more evidence, because you're right, the record wouldn't be replete, and we would have a hard time. But I do think on the record that you can easily make those findings that the presumption has not been rebutted.
I've interrupted you several times. I think I know what your argument is, but let me just—
Your Honor, it's always fun to appear in front of you when I prepare great arguments and you cut to the chase and pare everything down for me. I think we have really gone over exactly what I was going to talk in my prepared remarks.
Ms. Lee, I'll come back to you. And what do you think the significance I should give to the sworn affidavit from Mr. Potts that Mr. Curtis has put false testimony before the court, both in terms of documents and statements? Do you think I ought to just accept the record as it is, or do you feel like you would want to have an opportunity to depose Mr. Potts? You indicated that you hadn't had time to respond. Obviously, you recognize the significance of having two diametrically opposite statements under oath given to the court, both, and I would say to you that from the very beginning there's been a liberal use of accusation of people lying to the court, which the court is not used to that. I usually ignore out-of-court matters, because of the statement is insignificant. So what say you?
Our position, Your Honor, is that Mr. Curtis has rebutted the presumption of sufficient service. Given the court's comments and questions today, we certainly would welcome the opportunity to depose Mr. Potts or anyone else that the court, would give us leave to depose, if that would assist the court's determination here, and, I recognize and appreciate the court acknowledging that this is a significant issue, and we do understand that service is not a mere technicality, and we want to get the best, cleanest record before the court.
I mean, essentially, again, I recognize that I'm taking liberty this morning in terms of the rules of evidence, etc., in addition to the McGee case that was referred to there, and we certainly got the Fourth Circuit's opinion 901 that the North Carolina courts would recognize, and so we've got people who filed affidavits saying that I observed these transcripts and there were statements attributed to Mr. Curtis. Mr. Curtis has chosen not to deny. I have affidavits that Mr. Curtis filed before he retained you, Ms. Lee, several months after the default judgment was entered. But in his initial affidavits, it's obvious that he had consulted someone in terms of using legal terminology, etc. His affidavits did not say I never received the papers. There were YouTube comments by the time he filed those affidavits in. Yes, were you served the papers? Yes, and saying that he had had reasonable opportunity to respond to the court and by mistake just didn't do it. And so I admit that once he got a lawyer and came to you and filed an affidavit saying I never received it, and then I get affidavits saying that the things that he had put before the court in terms of legal writings are forgeries. I can't ignore the fact that I've got witnesses claiming that false testimony has been given. So I'm a little concerned, and I would assume that if I found personal jurisdiction, I know you would appeal my ruling. I know that you would advise your client the right to appeal.
Right.
Personal jurisdiction. So I am concerned about making a determination of credibility without having the full record, and I would have to tell you right now, but for the 24th of August affidavit, I would say that you've totally, audio distortion, presumption. I find it significant that Ms. Curtis has never said I didn't send them to him. I find it significant that in his multiple affidavits Mr. Curtis didn't say that. The only time he said it is in his the 24th of August affidavit. I do find I am troubled by that. I'm going to take under consideration what I think I ought to do, but if I were to say that I want to have a brief period of discovery restricted to the issue of whether or not, on the issue of service, other than Mr. Potts and Mr. Curtis, who is it that the parties would think ought to be subject to deposition testimony? I don't see a need that the legal assistant talks about how to use a barcode. I don't know why you would need to do that.
She'll appreciate that, Your Honor. I'm just thinking that, we might. Obviously those would be the two that, since those are the diametrically opposed affidavits, those would be the ones.
There's a flip side. If I feel like Mr. Curtis has lied to the court, then obviously I know what to do with that, and I know what to do with that in the face of a default judgment. If I find that Mr. Potts has lied to the court, I know what to do with that, and so I don't know that I can just ignore that. So, Ms. Lee, if I find in Mr. Curtis's favor, I've got a problem. What do I do with Mr. Potts?
I think
The court considers the matter of filing things under oath with the court of the utmost importance, and the response of the court to when someone says the court has not been given truthful information. The responsibility of the court, I believe, is very significant. Do I accept the statement that neither side should make a children's game out of the court?
I agree, Your Honor.
Your Honor, and I understand you're going to take it under. I believe you're going to take it under advisement and decide what you're going to do. My only, and this is going back to the other matter that you would have to decide if, depending on what you determine, if we have, whatever kind of discovery period, if it's delaying your ruling, then also I assume would delay, our motion to compel or our motion to show cause.
Let me cut through and ask Mr. Mayers and Ms. Lee both. If I order that Mr. Potts and Mr. Curtis would be subject to deposition, limited to the issue of matters filed with the court and the veracity of matters filed with the court, what's the minimum notice I need to give Mr. Curtis and Mr. Potts?
I would say probably a couple of weeks. I think that would be sufficient, Your Honor.
Do you have disruption, Mr. Potts, Mr. Mayers?
Other than the conversation shortly before, I had a brief conversation with him, and then so I don't know. I mean, I would assume I know I can get back in touch with him, but I don't know his schedule or how quickly we could schedule deposition.
I can certainly understand that he might want to be represented by counsel.
Sure.
I would say, Your Honor, a month would give sufficient time, and I'm not trying to delay this or push it out any further than it needs to be.
Well, I can tell you this, if I were to find this jurisdiction, time is not your friend, because the longer he chooses to ignore the judgment and being subject to jurisdiction, the worse it's going to get. So no, I think we all are interested in getting this thing drawn down to, but I think, Mr. Mayers, if I were to go forward with the record and find on the current record there's personal jurisdiction and say that I wanted to proceed with the order to show cause under default judgment, and Ms. Lee would file a notice of appeal, I would be divested of jurisdiction concerning that. So I think we need to get the record complete and get us to the point where I make a finding of personal jurisdiction. And Ms. Lee just says to her client, M.R. Curtis, you can appeal, but I have to tell you that if the Court of Appeals is going to find that Judge Gale had adequate opportunity and made a determination, that's going to be hard to overrule. You all would have to have honest dialogue with respect with your clients with regard to that. So I'm not sure I'm leaning towards taking it under advisement, as I might pretty well be persuaded that I want these people put under oath and give testimony so the court can understand it, the full dynamics, and you all be prepared. And so here's what I'm going to do. I'm going to ask, Mr. Mayers, that you advise Mr. Potts of what occurred today and make a determination as to whether he wants to seek counsel. If he chooses to retain you, then you and Ms. Lee and I can negotiate what the timetable is. If he decides to retain independent counsel, then we've got 3 people that need to be involved, and we would set a schedule down. So except for Ms. Lee's statement that she believes the court has jurisdiction to order Mr. Curtis to deposition solely restricted to the purpose of determining whether the presumption of service has been rebutted, and so if I hear that testimony, I don't want anything to deal with the underlying merits of the lawsuit. It would strictly be related to the issue of personal jurisdiction. I want to hold those as promptly as possible, but I feel like we've got to know whether or not Mr. Potts has separate counsel. Now, do you believe that? Now let's talk about this. Mr. Curtis and Mr. Potts certainly are involved. Does anyone? I don't believe that she said anything to prompt me to challenge her credibility, and so I don't for the court's purposes see any need to depose Mrs. Curtis. I can draw whatever inference or negative inference I want to what is or is not in affidavits, but if anybody feels like they need to depose Ms. Curtis, speak now or hold your peace.
I don't think so, Your Honor.
Agreed, Your Honor.
Alright. I think then what I'm going to ask is that, Ms. Lee and Mr. Mayers, you all get back to the court once you know whether or not Mr. Potts is going to appear with or without counsel, and if he gets counsel, then we need to find a date that works for 3 sets of lawyers, and I want to read the transcript, and I'm going to ask you to get a transcript on an expedited basis, and I will hold my determination as to personal jurisdiction until I see that testimony.
Okay.
And so I'm going to hold the ruling on the motion to set aside default and abeyance.
So you're not setting a time frame right now? You're saying get with Mr. Potts, and Ms. Lee can get with Mr.
I think the time frame to say as soon as possible.
Right.
So once you tell me you know whether Mr. Potts is going to get counsel or not, then I immediately want to have, if it's you, I immediately want to have you and Ms. Lee talk with each other, and you can propose to me, and I'll see whether or not I want to accelerate it or I'm going to accept what you have given me. If you tell me Mr. Potts has got independent counsel, then I would immediately want to have a telephone conversation with the 3 lawyers to set a schedule. I'm not going to give Mr. Potts unlimited time to find a lawyer.
Understood.
But, I recognize you're in a somewhat awkward position because you don't represent him on whatever at this point, but certainly Mr. Potts and Mr. Curtis both need to recognize that giving false testimony to the court has both civil and criminal implications. So it may very well be that testimony would be very quick, and I imagine the questions won't take long. But I do believe that when I make my determination and present the evidentiary record on which I make my determination one way or the other, because of the significance, I will have fully considered fully documented evidence. And having said that, I accept, Mr. Mayers, your argument that the record may be adequate already for me to find that Mr. Curtis's credibility is at issue, but we've got direct affidavit testimony from Mr. Curtis that says I did not receive it, and under the law that has significance if I accept and believe that testimony. Alright. Anything further either of the lawyers would like to talk to the court about? I'll let you speak without interrupting.
Nothing here, Your Honor. Thank you for your time today.
Nothing for plaintiff, Your Honor. Thank you.
Madam Court Reporter, again, I thank you very much for your time. And let me remind everyone again is that the only official recording and the transcript of what was or was not said in court today is Ms. Rogers. Any other statement does not have any audio distortion of the court. That being said, thank you for the attention of everyone, and the court will be adjourned.
Thank you, Your Honor.
Thanks.
Hearing concluded at 10:45 a.m. Certification of transcript. This is to certify that the foregoing transcript of proceedings taken on September 16, 2020, for the Guilford County Superior Court via WebEx is a true and accurate transcript of the proceedings as reported by me and transcribed by me or under my supervision. I further certify that I am not related to any party or attorney, nor do I have any interest whatsoever in the outcome of this action. This, the 22nd day of September, 2020.